Good afternoon, everybody. Thank you for joining me for the first of a series of 3 webinars I'm doing in the next 3 months concerning the determination of leases. My name's Edward Denehan, currently head of chambers at Nine Stone Buildings, and it's my pleasure to present this webinar this afternoon. Thank you for attending. As I've just mentioned, it's the first in a series of 3 webinars in which I address issues concerning the determination of leases. The next is on the 7th of April this year at 3 p.m. and the third in the series is on the 5th of May of this year, again at 3 p.m. Both those days are Thursday. The next webinar concerns forfeiture of leases, and the final in the series concerns surrender and frustration of leases. Please book early or register early to get the best seats. Today's webinar consists of 3 papers concerning the determination of leases in insolvency situations, although what I'll speak to is not exclusively limited to insolvency situations. Essentially, I'm concerned this afternoon with disclaimer of leases. The form of the webinars that I have put together over the last couple of years is as follows: that I'll bore you for a short hour. I hope it feels like a short hour, presenting my thoughts orally. I have produced fuller papers in support of what I say to you this afternoon, which will be distributed to delegates after the webinar has finished in the next couple of days or so. So I won't be speaking to everything that I've written down because that would take far too long and we don't have that time. I also don't accommodate questions, either oral questions from delegates or through chat or any other means during the webinar. It just doesn't work well in my experience. But what I am very happy to do is to address any general points or issues arising out of the webinar. If you email me, my email address is on our website and at the bottom of each of the papers, and I'll happily respond insofar as I'm able to your general points. Of course, I can't advise on any particular case, but I'm sure questions can be formulated in a way that will accommodate such an inquiry. So the first substantive matter I'm going to address concerns the dissolution of a limited company. Now, those of you who practice in insolvency will know that that insolvency is not the only circumstances in which a company may be dissolved, but it is one of them. And my goal this afternoon is to describe the impact of the dissolution of a company on its leasehold property that's owned by the company immediately before its dissolution. The bulk of what I say this afternoon in the context of the Companies Act 2006 and the Insolvency Act 1986 is not limited to leasehold property, although in certain respects leasehold property does have a slightly different regime, but applies to all assets and property of the company, be it cash, be it motor cars or whatever it might be. But because I'm a humble property lawyer, I have in mind throughout disillusionment and disclaimer in the context of the leasehold property owned by the company. Right. The first substantive point I wish to make is with reference to Part 31 of the Companies Act 2006, which is those 32 sections which appear on the screen, and this part is concerned with the dissolution of companies and their restoration to the register. It's all pretty straightforward. Section 1012, 1A and B of the 2006 Act provides that where a company is dissolved, all property and rights whatsoever vested in or held on trust for the company immediately before its dissolution are deemed to be bona vacantia. And bona vacantia is one of those expressions, a Latin expression. I don't think I ever came across it as an undergraduate at law school, but we use the literal translation means vacant or ownerless goods, ownerless property. Property must vest somewhere. And as we know, when a company is dissolved, it ceases to exist. And therefore, its property, real property, personal property and rights must go somewhere, and it vests bona vacantia. The consequence of property deemed to be bona vacantia or vesting bona vacantia is that the property belongs to the Crown or to the Duchy of Lancaster or the Duke of Cornwall for the time being, as the case may be. I'll come back to the distinction between those three entities in a second. The property vests and may be dealt with in the same manner as other bona vacantia accruing to the Crown, that's other assets, or to the Duchy of Lancaster or to the Duke of Cornwall for the time being. Section 1012(1) expressly provides that the property that may vest in the Crown or in the duchies, as the case may be, includes leasehold property. So leasehold property gets a specific mention, but property held on trust by the company for another person doesn't vest in the Crown or the duchies. Such property held on trust by the company is dealt with under the Trustee Act 1925, and there's a regime allowing for the appointment of other trustees and vesting orders and so on and so forth in that jurisdiction. I've given a little bit more detail about that in this first paper. It's expressly provided, and this is an important provision, that section 1012 has effect subject to the possible restoration of the company to the Register of Companies under section 1034. That's so provided by 1012(2) of the 2006 Act. I'll come on to describe the consequences of the restoration of a company to the register in a short while. Who deals with a property that is vested bona vacantia in the Crown or the duchies? I address this issue because it's important if one is wishing to deal with, say, a leasehold interest that is vested, who one speaks to, who one deals with. Well, the rules are pretty straightforward. If the company's last registered office and the asset in our world, the leasehold premises, were in England and Wales, but not the duchies of Lancaster and Cornwall, the property is dealt with by the Treasury solicitors. If the company's last registered office and property was in the duchies, its assets fall to be dealt with by the duchy solicitors, who are, surprise, surprise, Messrs. Farrer and Co. They are for the moment. I just found this interesting. The Duchy of Cornwall is the County of Cornwall, and the Duchy of Lancaster is Lancashire and most of Merseyside. For some reason, the Wirral is not included, and parts of Greater Manchester, Cheshire, and Cumbria, essentially where all the footballers live in the north of England. Details are contained very helpfully on the Farrer and Co.'s website, down to the finest detail. So if there's any issue as to where the who deals with the property bona vacantia, then that can be clarified by reference to that. If the registered office and the asset are in different jurisdictions, it's the registered office that usually determines who deals with the asset. As I say on the screen, that's a matter of practice, not of law. The government produced a very helpful, actually moderately helpful, bona vacantia guide, and I've given the reference on the screen there, which addresses those issues. For the going forward, I'll simply refer to the Crown rather than the other duchies, to the duchies. Otherwise, we spend all night referring to them. If the property becomes bona vacantia, it belongs to the Crown, and it doesn't have to deal with it in any particular way. The Crown may simply sell it in the open market to obtain the market value. Despite being a quasi-public body, the Crown owes no duty to anybody to get the best price. Importantly, in the context of property law, the Crown will usually disclaim commercial leases, and it doesn't assign such leases. The second paper in this webinar concerns the disclaimer, which is the method by which the leases are determined. Of course, I make this point that in the vast majority of cases, I'm probably right in saying the vast majority of cases, that the Crown will, in the first instance, be completely ignorant of the fact that property is vested in it bona vacantia, because there's no mechanism for anybody to inform the Crown immediately upon property so vesting. We'll look at a case later on in this webinar where it was 7 years before the vesting of a lease in the Crown came to the knowledge of the Treasury solicitors. So that can often happens. It usually arises when somebody approaches the Crown to buy the asset or apply for a vesting order. And the third paper that I speak to today deals with that. So now we've got the property, in our example, leasehold property vested in the Crown bona vacantia. As I mentioned earlier, that is subject to the restoration of the company to the register. Section 1034 of the Act makes it perfectly clear that the Crown may dispose of any property vested in it bona vacantia under Section 1012, notwithstanding the fact that the company may be restored to the register. That just makes it clear that the Crown doesn't have to sit on its hands once it knows the property is vested in it before dealing with the property. Who can apply for the restoration of a company? Well, I'm not really a company lawyer, but it includes a former company director, any person having an interest in the land, which the company had a superior derivative interest, any person having an interest in the land and other property that was subject to the rights vested in the company or was benefited by obligations owed by the company. And indeed, the court's got an overriding discretion to allow anybody it considers to have an interest in the matter to apply to have a company restored to the register. Over the years, I'm sure we've all come across cases where companies have been restored to a register for a specific purpose, serving or receiving a break notice, for example. If there's a successful application to restore the company, the restoration of itself doesn't affect any disposition of the company's property by the Crown under its powers that we've just considered. That's Section 1034(2)(a) of the 2006 Act. However, if that occurs, the Crown must pay the company, and it's the payment to the company, which has now been resurrected as a legal entity, an amount equal to the consideration received for the property or the value of such consideration at the time of the disposition. And that's provided for by Section 1034(2)(b)(1) and 2. If the Crown receives no consideration on the disposition, the Crown must pay the company an amount equal to the value of the property disposed of as at the date of the disposition. That's provided by Section 1034(2). Having said that, in calculating the amount that must be paid under these provisions, the Crown may deduct from the amount paid to the company the reasonable costs of the Crown representative in connection with the disposition. The Crown representatives are the Treasury solicitors or Farrow & Co., depending upon whether it's the Crown or not. If an order is made restoring the company to the register, the dissolution is treated as being void ab initio, and any property of the company that vests in the Crown bona vacantia is treated as never having been so vested. So what that means is that the resurrection of the company by its restoration means that the property belongs again to it, unless it's been disposed of by the Crown, and that the mechanism of that doesn't involve any revesting, conveyance, transfer by the Crown to the company. As a matter of law, the company will again be the owner of the property without more. The Details of the mechanism for applying for a payment from the Crown if a company's property has been disposed of on a restoration is out with the ambit of this webinar, but it's really straightforward. One just fills in a form. It's called RA15, and I've got a copy of a RA15, and I'll attach it to this first paper. So that's what I want to say about dissolution of a company. So the hypothesis going forward is that in respect of the property of a dissolved company, it's vested in the Crown bona vacantia, and the Crown may or may not know about it. And now I go on to consider the real nub of what we're here for this afternoon, namely disclaimer and how leases may be determined by disclaimer. There's mechanisms both for the Crown and in the insolvency situation that we'll consider in a moment. The starting point is section 1013 of the 2006 Act, and that provides that the Crown has a statutory right to disclaim its title to any property vested bona vacantia by notice signed by the Crown representative, namely the Treasury Solicitor, or FARAs, if we're talking about the duchies. And the Crown can exercise this statutory right without prior notice to any person whatsoever. The power to disclaim is inevitably exercised in relation to difficult or problematical land, land which has a limited value, or where it would not be cost effective to dispose of the land. The Crown usually disclaims property subject to onerous conditions or other potential liabilities and particular commercial leases. My experience has been that unless it's a clean, pure asset with value, land with value, lease with value, it'll simply be disclaimed by the Crown. It really is as brutal as that. There is a mechanism for this. A notice of disclaimer under section 1013 must be delivered to the registrar of companies by the Treasury Solicitors and retained and registered by him. That's provided under section 1013(6) of the 2006 Act. Copies of the notice of disclaimer are published in the Gazette and sent to any person who has given notice to the Crown representative that they claim to be interested in the property. And as I mentioned earlier, the Crown may not have received such notification, but what sometimes happens, and in my experience inevitably happens, is that somebody pops up and approaches the Treasury Solicitor and says, I want to buy, or I'm going to apply for a vesting order in respect of certain property, lease or freehold land. That gives notice to the Crown that in fact the property has vested bona vacantia, and on that occasion the Crown will then disclaim the lease in the manner that I'm describing now. The notice of disclaimer, there is a time limit. A notice of disclaimer must be executed by the Crown within 3 years after the following dates: the date on which the property may have vested in the Crown under section 1012 first came to the notice of the Crown representative. So the clock only begins to run against the Crown when it receives notification, or it comes to its knowledge that the property has vested bona vacantia. And as I touched upon more than once now, that may be many years after the actual vesting. Or if the ownership of the property is not established at that date, the end of the period reasonably necessary for the Crown representative to establish ownership of the property. What that means is if the Crown representative has to carry out investigations to find precisely whether the property is vested in it, the Crown bona vacantia or not, time begins to run after a reasonable period that's been necessary to establish that one way or the other. And in some cases, it can be quite complicated to find out whether the property is vested or not. I won't bore you with an example right now. If this is not done, any notice of disclaimer served by the Crown is of no effect. So it is a significant time limit, and therefore the Crown is burdened with the property. It's possible for persons to put the Crown to its election whether or not to disclaim property. A person interested in the property vested in the Crown bona vacantia may apply in writing to the Crown representative, requiring him to decide whether or not they will disclaim, the Crown will disclaim. And if the application is made, any notice of disclaimer must be executed within 12 months after the making of the application, or such further period as the court may allow. So, as I say, a person interested in the property can put the Crown to its election. If this is not done, a notice of disclaimer is not effective. This is important. The right of the Crown to execute a notice of disclaimer under Section 1013 may be waived by or on behalf of the Crown, either expressly or by taking possession of, an example I've given is leasehold property. I've never come across the Crown taking possession of any property or expressly saying that they are waiving their right to disclaim. A very much more cautious approach to the issue of disclaimer is displayed by the Treasury solicitors. Section 1016 of the 2006 Act is expressly concerned with leasehold property, and it's there provided that a disclaimer of leasehold property, or I think the expression is property of a leasehold nature, not defined, does not take effect unless a copy of the disclaimer has been served on every person claiming under the company as an under lessee or mortgagee, and no application under Section 1017 for a vesting order is made with respect to that property before the end of the period of 14 days, beginning with the day on which the last notice under 1016 was served, or two, where such an application made, the court directs that the disclaimer shall take effect. What that means is this, that I'm putting it in the vernacular, the Crown must give a mortgagee or a subtenant the heads up, if you will, that it wishes to disclaim the lease, thereby giving the subtenant or the mortgagee they both can apply under Section 1017 for a vesting order. Applying for vesting orders and the court's jurisdiction in respect of vesting orders is the subject of the third paper that I will speak to this afternoon. So in the case of leasehold property, that notice must be given. And effective disclaimer by the Crown, we're getting to the nub of it now. Leasehold interest in property is extinguished on disclaimer by the Crown, and the leasehold property is deemed not to have vested in the Crown under Section 1012 or at all, so provides Section 1014 of the 2006 Act. Right, so that's disclaimer by the Crown. What about disclaimer by liquidators? We're now in the Insolvency Act. I hope we are in the Insolvency Act 1986, Section 178. That provides that the liquidator of a company that is being wound up in England and Wales may, by giving of prescribed notice, disclaim any onerous property, and may do so notwithstanding that he or she has taken possession of the property, endeavored to sell it, or otherwise exercise rights of ownership in relation to it. I pause there for a second. I state something that I hope is obvious, that in the context of the insolvency legislation, the company hasn't been wound up as yet. We've got the liquidation situation, and therefore, for the purposes of liquidating the company and for the benefit of the creditors and so on and so forth, it may be appropriate for the liquidator to be rid of onerous property, and that is done by disclaimer. Onerous property is defined in Section 178(3) of the 1986 Act. It's any unprofitable contract, any other property of the company which is unsaleable or not readily saleable, or is such that it may give rise to a liability to pay money or perform any other onerous act. Eyre and Hall, a case decided in 1986, which I refer to in the notes and on the PowerPoint slide, supports the proposition that a lease which contains tenants' onerous covenants is onerous property for the purposes of section 178. The effect of the disclaimer by liquidators is described in section 178.4 of the 1986 Act. It operates to determine, as from the date of the disclaimer, the rights and interests and liabilities of the company in or in respect of the property disclaimed. So again, putting it in the vernacular, the company is off the hook in relation to their onerous property. In our case, we would say onerous covenants in a lease, for example. However, and this is important, the disclaimer does not, except so far as it is necessary for the purposes of releasing the company from any such liability, affect the rights or liabilities of any other person. And that has quite complicated consequences in the context of leases. Again, under the 1986 Act, the liquidator can be put to his or her election. It's provided by section 178.5 of the 86 Act that a notice of disclaimer cannot be given in respect of any property if a person interested in the property has applied in writing to the liquidator, requiring the litigator to decide whether or not he or she will disclaim the lease. And the period of 28 days beginning with the day on which the application was made, or such longer period as the court allows, has expired without a notice of disclaimer having been given under section 178 in respect of that property. One can see a landlord, for example, whose tenant is in liquidation, may want to force the issue with the liquidator, so the landlord can perhaps get the property back and do what the best it can with it. And there are no doubt endless circumstances when it be to the advantage of a person interested in the property to know one way or the other whether the lease is going to be disclaimed. Any person sustaining a loss or damage as a consequence of the operation of a disclaimer under 178 of the 86 Act is deemed to be a creditor of the company to the extent of that loss and damage, and may prove for the loss and damage in the winding up. Clearly, a landlord whose rental role is determined by the disclaimer of a lease would be such a person, and there's quite interesting cases, which of course I'm not dealing with today, about how one quantifies the loss and damage of a landlord where a lease has been disclaimed. Again, specific provision is made in the 86 Act dealing with disclaimer of leasehold properties, and one finds the relevant provision in provisions in section 179 of the 1986 Act. A disclaimer under section 178 of any property of a leasehold nature does not take effect unless a copy of the disclaimer has been served, so far as the liquidator is aware of their addresses, on every person claiming under the company as under lessee or mortgagee, and no application is made under section 181 of the 86 Act before the end of a period of 14 days, beginning with the day on which the last notice was served, or where such an application has been made, the court directs that the disclaimer shall take effect. Section 181 of the 1986 Act is concerned with vesting orders when there's a disclaimer by liquidators. Again, the subject of the third paper that I'll speak to today. And merely because one makes an application for a vesting order doesn't mean that the court will make one. We'll come to consider that jurisdiction in a short while. And so that's why 2 is there, because the court may well direct that the disclaimer takes effect in any event. In this Rehan's Place case, it was decided that the court doesn't have a general jurisdiction to interfere with the liquidator's decision to disclaim of any company's property unless the liquidator has acted in bad faith. So it's entirely a matter for the liquidator whether he or she decides to serve notice of disclaimer or not. Again, not being a company lawyer, I'm sure that there are circumstances in which a liquidator's decision could be challenged by those interested in the liquidation of the company. But as I say, there's no general jurisdiction, and certainly the liquidator doesn't need the permission of the court in order to disclaim a lease. The second situation, insolvency situation where disclaimer arises, of course, is by trustees in bankruptcy. And I apologize in advance, there's a lot of overlap between the provisions in the 86 Act concerning trustees in bankruptcy and liquidators. I'm apologizing not because I wrote it, but just because the themes are the same, but I've addressed them all in the papers nevertheless, and I'll skip through them now. Section 315 of the 1986 Act provides the trustee in bankruptcy may, by giving a prescribed notice, disclaim any onerous property, and may do so notwithstanding that he or she has taken possession of it, endeavored to sell it, or otherwise exercise rights of ownership in relation to it. This exception, both in the context of trustees and in liquidators, is necessary because it may well be that it's in the best interest of the creditors of the company or the individual, as the case may be, the bankrupt, that the liquidator or trustee makes efforts to realize the value of a lease, for example, in our case, but that comes to no positive conclusion, and therefore there's no option but to disclaim. If there wasn't this, if you like, wriggle room allowing the liquidator or the trustee to sell or exercise rights of ownership or take possession to protect the property, then the liquidators would simply disclaim, and the trustee would disclaim without more, which is not in the best interests or may not be in the best interests of the creditors. Onerous property has the same meaning as that prescribed by section 178(3) of the 86 Act, which we looked at above. And of course, onerous covenants on the part of a tenant would be onerous property for these purposes. The effect of disclaimer under the 1986 Act by a trustee has a familiar ring. It operates so as to determine from the date of the disclaimer the rights, interests, and liabilities of the bankrupt and his estate in or in respect of the property disclaimed, and discharge the trustee from all personal liability in respect of that property from the commencement of his or her trusteeship. That's an important provision, that the trustee does not acquire, if that's the right way of putting it, any personal liability for dealing with the property before it's disclaimed. Again, that's a matter of practice. As with disclaimer by liquidators, the effect of the disclaimer is focused on the impact on the bankrupt, and save to that extent, the trustee and the bankrupt are immune. As I said, the disclaimer doesn't affect the rights and liabilities of any other person. So it's not as if the disclaimer brings to an end any potential liabilities or rights arising out of the disclaimed property, in our case, a disclaimed lease. As with the position in corporate insolvency, a person suffering a loss or damage in consequence of the operation of a disclaimer under section 315 of the 86 Act is deemed to be a creditor of the bankrupt to the extent of that loss and damage, and may prove for that loss and damage as a bankruptcy debt. Again, there is provision for the trustee to be put to his election, and no notice of a disclaimer can be given under section 315 of the 86 Act in respect of any property if the person with an interest in the property is applied in writing to the trustee, requiring the trustee to decide whether or not to claim, and within 28 days, beginning on which the application is made, a notice of disclaimer has not been given in respect of that property. As I touched upon earlier, maybe very much in the interest of somebody with an interest in the property to know sooner rather than later whether the property is to be disclaimed or not. Disclaimer of leasehold property, section 317 of the 87 Act is concerned with disclaimer of leaseholds, and it's the same effect as section 179 that we looked at earlier, namely notices to underlessees and mortgagees. There is an extra provision. This is unique to trustees in bankruptcy, and that arises where the property to be disclaimed is a dwelling house. We can have obviously a lease of a dwelling house, and that's addressed in section 318 of the 86 Act. Without prejudice to the trustee's ability to disclaim, the disclaimer of any property in a dwelling house doesn't take effect unless a copy of the notice of disclaimer has served on every person in occupation or claiming a right of occupation in the dwelling house, insofar as the trustee knows of their addresses. Well, if they're in occupation of the dwelling house, one assumes that that's where they live and that's their address, but hey ho. And no application is made under section 320 of the Act in respect of that property, beginning with the end of the period of 14 days. That's the provision allowing an application for a vesting order, or where such an application has been made, the court directs that disclaimers to take effect. Of course, that doesn't arise in the context of corporate insolvency because corporations can't reside anywhere, but this gives a protection for those who are in occupation or claim to be entitled to occupy a dwelling house, which is the subject of a disclaimer. It's a bit of a trip down memory lane when preparing this paper by reference to what's quite an old case now, although it did ruffle a few feathers when it was decided back in 1996. The Hindcastle and Barbara Attenborough Limited case gives some useful insights as to the workings of the impact of disclaimer in the insolvency situation. So not where the Crown disclaims property, the lease, but rather when liquidators and trustees disclaim leases. The case itself concerned the liability of sureties of an assignee of the tenant under a lease that had been disclaimed by the liquidator of the assignee tenant. The case, notwithstanding it's 96-97, the case was decided before the provisions of the Landlord and Tenant Covenants Act 1995 came into force, which was the 1st of January 1996. So in many respects, the case wouldn't arise today, but notwithstanding that, the House of Lords, particularly Lord Nichols, gave some useful guidance as to the operation of those provisions in the 1986 Act that I've troubled you with earlier on. In the first instance, the judge described the fundamental purpose of those comparable provisions that we've looked at. I set out his thoughts in the paper, but I needn't trouble you with them this afternoon. More helpfully, I suggest I can turn to specific examples that he gave as to the workings of those provisions without reference to any authorities, which makes it clearer. And the first situation the court or Lord Nichols addressed was where there's a landlord and an insolvent tenant. So there's only two people involved. And in such a situation, the disclaimer by the liquidator or indeed the trustee of the insolvent tenant operates to determine all the tenant's obligations under the tenant's covenants and all the tenant's rights under the landlord's covenants. The tenant can't have it both ways. It doesn't get the benefit because it loses the burdens. The landlord's obligation and rights are also determined. The landlord can't pursue the tenant on its covenants because that would be inconsistent with the purpose of the provisions, namely to protect the insolvent tenant from its creditors. As the tenant's interest in the property, in our case, a lease, is determined, the effect is that the reversion is accelerated into the hands of the landlord. Lord Nichols then considered the case of a landlord, an insolvent tenant, and a guarantor. In this situation, the liabilities of the insolvent tenant to the landlord are ended on disclaimer, as we've just considered, but not so as to affect the obligations of the guarantor to the landlord. That's the effect of Section 178(4) of the 1986 Act. As between the landlord and the guarantor, the lease is deemed to exist. It's the deeming provision that saves the lease, as it were, as between the landlord and the guarantor, because releasing the guarantor is not a vital ingredient in protecting the tenant from its creditors. Disclaimer also ends the insolvent tenant's liability to indemnify the guarantor, but not so as to affect the mutual rights and obligations as of the landlord and the guarantor. What's the position if there's an insolvent tenant and a subtenant? In order to free the tenant from liability, it's necessary to extinguish the landlord's rights against the tenant and also the subtenant's rights against the tenant. Can't have the subtenant pursuing the insolvent subtenant for breaches of covenant and so on and so forth. That is inconsistent with the fundamental purpose of the provisions that we're now considering. The tenant's interest in the property is determined, as we've said, but not so as to affect the interest of the subtenant. The interest of the subtenant continues, and he or she holds his estate on the same terms and subject to the same rights and obligations as would be applicable if the tenant's interest had continued. So that's the position in respect of disclaimer. That's the mechanisms by which leases may be determined in insolvency situations and when the assets of a dissolved company vest in the Crown bona vacantia. The final paper I want to speak to this afternoon concerns vesting orders. Now, this is not directly on point in the sense that it's got nothing to do with the determination of leases, for example. It's indeed quite the reverse. But it seems to me, and this is why I'm addressing it, that it's a vital ingredient in the scheme of disclaimer. And I start again with Crown disclaimers and vesting orders. And here we're back to the Companies Act 2006 and Section 1017. That provides that the court may, on an application by a person who, one, claims an interest in the disclaimed property, or two, is under, I'm paraphrasing, a continuing liability which is not discharged by the disclaimer, to make an order under Section 1017 in respect of that property. I would like you to note there that this section defines who can apply. A person who claims to have an interest in the disclaimed property and somebody under a continuing liability. I emphasize that for a reason that will become apparent in a second. An order under Section 1017 is an order for the vesting of the disclaimed property in or its delivery to, one, a person entitled to it or a trustee for such person, or two, a person subject to a liability as is mentioned in Section 1017 1b, that's the person under a continuing liability. In respect of person two, person who's subject to continuing liability, the court will only make an order if it is considered to be just for the purposes of compensating that person who is subject to the continuing liability. Now, one can see immediately there's not a direct correlation between Section 1017(1) and 1017(2). Remember, under A of both those 17(1), a person who claims an interest may apply for a vesting order, but the order can only be made vesting a person who is, quote, entitled to the property, as I've highlighted on the screen. This recent case of Leon and the Attorney General supports that proposition, namely that the two are not the same, and therefore merely establishing that one has an interest in the property, the reversion expected upon a lease, for example, does not entitle one to a vesting order. And that's, as I say, made clear by this case of Leon and the Attorney General. The facts of that case are really quite involved, and I've set them out at some tedious length in the paper, but I won't speak to it now. The point that I've highlighted on the section I've quoted on the PowerPoint is the gist, if you will, the ratio of the case. To be entitled, it means the court will make a vesting order in the favor of a person whose interest in the disclaimed property is such as, in the judgment of the court, entitled to the applicant to the property in the circumstances of the case. Now, as a general proposition, that's always very straightforward, but what does it actually mean? Other than simply repeating the provision in the Act itself, namely, one's got to be entitled to it. Well, it seems to me that the circumstances are that an applicant will have to show he or she has an interest in the property, a property interest, I will suggest in a moment, and that in all the circumstances, which are many and varied, that person, A, let's call it A, is more entitled to it than anybody else. And as you understand, and as is emphasized in the Leon case, that there may be competing applications for a vesting order. I did a case recently where my client was applied for a vesting order to have freehold of a building vested in it, the freehold having vested in the Crown bona vacantia, because the freehold owner had been dissolved, not an insolvency situation, it had been struck off because it hadn't done its accounts or something. My client, social housing provider, had a long lease of the upper floors of this building, which contained, I think it was 24 flats, which it let out to as social housing. There were 3 commercial units on the ground floor, but my clients had interest in the basement, common parts, and so on and so forth. And what had happened is that my client's lease was a virtual freehold. It's 999-year lease from a date, I think it was in 2018, paid £4 million for this lease. But also the commercial leases had been granted on for capital payments for premiums on 999-year leases too. My clients wanted the freehold because a massive damage had been caused to the building by wind, and the roof had come off, and so the top floor couldn't be used. And so we applied for a vesting order, and it didn't take very much to persuade the master that in the overall scheme of things, that my clients were entitled to the property because they had a virtual freehold of 99% of it, not 99%, 90% of it. Now, to be fair, in that case, there wasn't a competing applicant, albeit that one of the commercial tenants had rather half-heartedly communicated with the Treasury solicitors and said that they might want to buy the freehold, but that was really a non-starter, although it did delay the proceedings somewhat. But it's impossible for me to give a definitive statement as to what interest one might need to prove in order to satisfy the court that one is entitled to the property, as the observations in the Leon case confirm that it all depends upon the circumstances of the case. And if I want to put it crudely, that person who seems to have the bigger, most valuable interest in the property is probably the one who is going to succeed if there's a competition. If there's nobody, as in my case, who's seriously making an application, then it may well be that a very minor interest would be sufficient. In the Leon case, Mr. Leon, who didn't have a personal interest in the lease in question, he didn't get a vesting order. Ultimately, the Court of Appeal said he shouldn't get it, but it was a mortgagee who did. So there was a competition there, and it was said that the mortgagee was the person entitled, and then they would sell the very valuable flat and distribute the net proceeds of sale to those entitled, which included Mr. Leon. Section 1018 of the 2006 Act is concerned with leasehold property. A court mustn't make an order under 1017 of the Act vesting property of a leasehold nature unless the dissolved company as under lessee or mortgagee, except on terms that the person who in whom the property is vested takes it on the same liabilities and obligations to those to which the company was subject to, or subject to the same liabilities and obligations if the lease had been assigned to the applicant. So if you're an under lessee or a mortgagee, you've got to essentially take the burden of the lease as have been disclaimed. If no person claiming under the company is willing to do that, the court has power to vest the company's estate and interest in the property in any person who is liable to perform the lessee's covenants in the lease. That would be a surety, for example. Yes, as I say, this would allow a surety to take the lease. Vesting orders in the context of disclaimer by liquidators, section 118 of the 86 Act. If there's been a disclaimer by a liquidator, an application may be made by any person who claims an interest in the disclaimed property, or any person under a continuing liability, a familiar formulation that we've just looked at. A couple of cases in the Vedme case, late Gavin Lightman, sitting as a Deputy High Court judge then, held that a statutory tenant under Section 2 of the Rent Act 1977 had a sufficient interest in the disclaimer head lease to make an application under Section 181(2). And you'll remember, those of us who are old enough to remember, that a statutory tenant under Section 2 of the 1977 Act doesn't have a property interest in the house or flat that they occupy, only a status of irremovability. So that was a generous decision. The Court of Appeal in the Leon case, without saying that Vedme was wrongly decided, said that the reading of Section 181(2) was far too wide. My view is that in order to successfully apply for a vesting order under these provisions, one must prove that one has some proprietary interest in the disclaimed property. Again, as in the context of vesting orders under the 2006 Act, the court may make a vesting order in such terms as it thinks fit in a person entitled to it, or a person entitled under a continuing liability. I suggest the words entitled to it in section 118(1) of the 86 Act will be given the same meaning as they were in the context of the 2006 Act, as described in the Leon case. Any person who suffers loss and damage as a result of the disclaimer can prove in the liquidation, as I've said, and but the compensation that any person any loss and damage that such a person seeks to prove in the liquidation must take account of the fact, that that person has received a vesting order in it, because that will obviously diminish any loss and damage, well, obviously, but will in many cases reduce the loss and damage which that person will suffer. Very conveniently, if a vesting order is made under section 181 of the 86 Act, the property vests in the applicant without there being conveyance, assignment, or transfer. In the recent case I've done, and in previous cases I've done, one simply has the order of the Chancery Master saying property now vests free of encumbrances in the claimant, and one makes an application to the land registry to be registered in substitution for the, in this context, company, and there's no need for any assurance, if you will, by any person to the successful applicant. Again, the specific provision made in respect of the vesting of property of a leasehold nature. Again, it's on the same terms as we considered in the context of vesting orders in the Crown. The vesting order must be on the same terms as the terms of the lease, and if the court thinks fit, making the successful applicant for the vesting order liable as if the lease had been assigned to him or her. Again, if nobody's prepared to take a vesting order on those terms, the court may vest the lease in anybody who's under an obligation to perform the tenant's covenants, and any such vesting is freed from and discharged from any estates, encumbrances and interests created by the dissolved company, and that would include, for example, charges. But again, as I've touched upon previously, a mortgagee would be a person entitled to apply itself for a vesting order, and in the Leon case, that's what happened, and the mortgagee was successful as against Mr. Leon, who was the sole owner and proprietor of the dissolved company. If a person claiming under a dissolved company as under lessee or mortgagee declines to accept an order under section 181, that person is excluded from all interests in the property. Final section of this paper concerns vesting orders in the context of disclaimer by trustees in bankruptcy. They substantially mirror the provisions in the 86 Act that apply in respect of vesting orders made in the context of liquidation. So I can take this quite quickly. Section 320 contains the general provisions empowering the court to make a vesting order on disclaimer by a trustee. In addition to persons claiming an interest in the disclaimed property and persons under a continuing liability, in the context of personal bankruptcy, a vesting order may also be made where the disclaimed property is a dwelling house by a person who at the time of the bankruptcy application was in occupation of or entitled to occupy the dwelling house. That's a discrete provision in the context of personal bankruptcy. Section 323, or subsection 3 of the 86 Act mirrors 181.3. It also provides that a vesting order may vest disclaimed property, being a dwelling house, in any person at the time when the bankruptcy application was made was in occupation of or entitled to occupy the dwelling house. The provisions in section 181.4, 5 and 6 are reproduced in 320, 4, 5 and 6 in the context of trustees, mutandis mutatis, and the same with section 321. So I needn't read those out. That's the end of the papers, dead on time, if I can say so myself. As I say, the provisions are pretty dry, but they're set out at length and accurately, I hope, in the papers which will be sent to delegates. And I remind delegates that if one has any questions arising out of these papers, please feel free to email me at the address that you find it on the website or at the bottom of the papers. And I thank you again for spending some of your time this afternoon on this matter. And I hope that you'll be able to join me in April and May for the next two webinars dealing with determination of leases in different ways. Good afternoon.